There are a lot of people out there that think they know exactly what the Constitution says, but many of them are wrong. This video is going to cover the top 10 biggest misconceptions about the US Constitution that I see repeatedly in pop culture. But before we begin, I've got 10 misconceptions to go through and not that much time to go through them, so each explanation is going to have to be kept pretty short and pretty oversimplified. If I talk about something that you'd like more information about, comment below and I might be able to make a full video on that topic. Let's get into it. This is probably the biggest thing I see people completely misunderstand. You do not have the right to just say whatever you want to whoever you want without any consequences. The First Amendment of the Constitution states that Congress shall pass no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people to peaceably assemble, and to petition the government for a redress of grievances. The explanation for this first misconception is right there in the first sentence: Congress shall pass no law. The First Amendment does not say anything about anyone else. It only says that Congress must respect your freedom of speech. Your freedom of speech protects you from the government only. Private citizens and private companies are not bound by it. This means that while the government can't punish you for what you say, if you post a racist or otherwise hateful comment on social media, it can be taken down and your account can be suspended without violating any of your constitutional rights. This is something I might make a more in-depth video about in the future, but building off the last one, even when dealing with the government, your right to free speech is not absolute. This comes from a case called Cox v. New Hampshire. In 1939, a group of Jehovah's Witnesses decided to have a parade down the sidewalk of Manchester, New Hampshire. However, the municipality of Manchester had an ordinance that prevented anyone from having a parade without a license. The Jehovah's Witnesses didn't have a license, but decided to have their parade anyway, and were fined for violating the city ordinance. The Supreme Court, on appeal, said that civil liberties, as guaranteed by the Constitution, imply the existence of an organized society maintaining public order, without which liberty itself would be lost in the excesses of unrestrained abuses, and the control of travel on the streets of cities is the most familiar illustration of this recognition of social need. This is the case that really established what have become known as time, place, and manner restrictions on speech. So long as a regulation is content neutral, meaning you can't regulate speech based solely on what you're saying, narrowly tailored to serve a significant government interest, and leaves open alternative ways of communicating the speaker's message, then regulations regulating free speech will be allowed to stand. So no screaming about UFOs in the park at 2 a.m. This is another one I might make a more in-depth video on one day if there's interest. We were all taught in high school, or at least I was, that the Third Civil War Amendment, the 15th Amendment, gave former slaves the right to vote. But it turns out that that was wrong. In Article 2, Section 1, the Constitution states, "Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress." Let me go ahead and highlight the most important part of that. In such manner as the legislature thereof may direct. This sentence means that states get to decide how elections are going to run, and that includes deciding who is going to be allowed to vote. Now, right now you're probably thinking, okay, sure, that's how it used to be, but didn't the 15th Amendment change that? Short answer, no. The 15th Amendment states, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude." This doesn't really change all that much. It doesn't say all people born in the US are allowed to vote. It also doesn't say that all previously enslaved people are allowed to vote. It just says that states cannot deny the right to vote based on race, but then continues to leave it up to the states to decide the manner in which elections are held. In 1873, the Supreme Court said, in a case known as United States v. Reese, the 15th Amendment does not confer the right of suffrage upon anyone. It prevents the states or the United States, however, from giving preference in this particular to one citizen of the United States over another on account of race, color, or previous condition of servitude. Before its adoption, this could be done. All the 15th Amendment did was prevent states from denying the right to vote on account of race. It left open the possibility of denying the right to vote for other reasons. And many states went out of their way to find other reasons to deny people of color the right to vote, such as poll taxes, education requirements, and literacy tests. Of course, since then, there have been Supreme Court cases that have outlawed many of the reasons that states used to use to prevent people from voting. But I've included this in my list of misconceptions because voting rights are much more complicated than people generally think. If you were to read through the Constitution looking for the sentence that specifically guarantees the right to vote, you're not going to find it. All those rights that the Bill of Rights grants us, as they're written, they don't apply to the states. In 1833, when presented with this very issue, the Supreme Court stated that the Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the government of the individual states. The powers they conferred on this government were to be exercised by itself, and the limitations on power, if expressed in general terms, are naturally, and we think necessarily, applicable to the government created by the instrument. In modern English, the court is saying the Constitution created the federal government, and then the states were created by their own separate constitutions. Therefore, the federal Constitution only applies to the federal government. The federal government wasn't able to restrict your freedom of speech, but a state government could if it wanted to. Now, this has been largely done away with. Most of the rights guaranteed by the Bill of Rights have been applied to the states through a process called incorporation. However, because of this precedent, applying the Bill of Rights to the states ended up being a lot more complicated and has taken a lot longer than you might have thought. For example, the right to keep and bear arms was only very recently found to apply to the states in 2010 in a case called McDonald v. City of Chicago, and there are still other rights in the Bill of Rights that haven't yet been incorporated. I see so many people throwing around phrases from the Constitution as if it's the simplest thing in the world, but it very much is not. Constitutional law is one of the most complicated areas of the law. This is the actual textbook that I was assigned when I took con law during my first year of law school. It's 3 inches thick, it weighs 7 pounds, has 1,022 pages, and is far and away the biggest book that I was ever assigned during my 3 years in law school. Let's take a look at just the 14th Amendment. Part of one sentence in that amendment states that no state shall deprive any person of life, liberty, or property without due process of law. No state shall deprive any person of liberty, but what does liberty mean? I know what it means to me, but it likely means something different to you. So which idea of liberty are we protecting? Did the framers have a specific idea of liberty in mind, or was this word used to keep things intentionally vague? The Constitution is riddled with this kind of vague or overbroad language and has led to literal centuries of lawsuits and debate. Anyone who tries to convince you that the Constitution is clear-cut is misleading you, and that's why this misconception is on this list. There's a lot more I could say on the 14th Amendment, so much so that while I might make a video about some of the other entries in this list, I know I'm going to make a video about this one. I've already done all the research and planned it all out. I just need to film and edit it, and it'll be coming out next week. At least I hope. If I've left this part in the video, it means it's coming out next week. So subscribe to make sure you don't miss it. The Sixth Amendment states that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. And the Seventh Amendment states that In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. It seems simple, right? You are entitled to a jury trial in all cases, whether criminal or civil. Well, as we've already talked about, the Constitution is rarely that simple. In 1937, the Supreme Court in District of Columbia v. Clawens held that the Sixth Amendment, even though it says it applies in all criminal cases, actually secretly doesn't apply in so-called petty offenses. This is because at the time of the adoption of the Constitution, there were numerous offenses commonly described as petty, which were tried summarily without a jury. I'll go into more detail about this in that video that I have planned for next week, but long story short, the thinking is that if the founders passed this amendment and then continued to try petty offenses without a jury, then they could not have meant for the amendment to prevent this practice. The Supreme Court has defined a petty offense as any crime punishable by 6 months of jail time or less. Personally, I wouldn't consider the threat of spending the next 6 months in jail to be a petty thing, but that's where the law stands. As for the Seventh Amendment, the one concerning jury trials in civil cases, remember a couple misconceptions ago when we learned that the Bill of Rights does not automatically apply to the states? During that discussion, I mentioned that there are some rights that haven't been applied to the states yet, and this is one of them. The federal government is required to have a jury trial in all civil cases, but states aren't. To be clear, depending on your state, you might actually have this right anyway, but it's a right that comes from your state constitution, not the US Constitution. If you've ever watched a cop movie or TV show, you've probably heard the phrase, "If you cannot afford an attorney, one will be provided for you." This, at least partially, comes from a different part of the Sixth Amendment, which states that in all criminal prosecutions, the accused shall have the assistance of counsel for his defense. This led many people to believe that they are guaranteed an attorney anytime they are accused of breaking the law, but that isn't true. Prior to 1963, the Sixth Amendment did not apply to the states. This changed when the Supreme Court handed down their opinion in Gideon v. Wainwright. However, in Gideon, the Supreme Court said that states are only required to provide an attorney when the defendant is indigent. That means that if you make too much money, you need to go find and pay for your own attorney. Remember that the famous phrase is, "If you cannot afford an attorney, one will be provided for you." There's no magic number that will qualify you for a public defender. It's evaluated on a case-by-case basis. However, generally speaking, to qualify for a free attorney, you'll need to have an income level that is below 125% of the federal poverty guidelines, and depending on your state, your income might even need to be lower. To put that into perspective, in 2025, a single person with no children or other dependents would need to make less than $19,562 per year to qualify for a free attorney. Assuming you're working full-time, that's a salary of $9.38 per hour. Now, that's already a pretty big restriction, but it gets even more complicated. In 1979, in a case called Scott v. Illinois, the Supreme Court clarified that this right to an attorney for indigent clients only exists in cases where a jail sentence is given. So even if you meet the income requirements, if you're accused of a crime where the maximum punishment only includes a fine, the state is not required to give you an attorney. What's more, none of this applies in civil cases. You'll note that the Sixth Amendment starts in all criminal prosecutions. If you're being sued or charged with a civil offense, you're on your own. The Sixth Amendment only applies in the criminal context. I see a lot of people that believe they have a constitutional right to be served at restaurants or by other businesses, but this is very much not the case. This whole idea stems in part from a 1958 Supreme Court case called NAACP v. Alabama. In that case, the Supreme Court found that held within the free speech that is protected by the First Amendment is the freedom to associate with different groups of people. This is because effective advocacy of both public and private points of view, particularly controversial ones, is undeniably enhanced by group association, creating a close nexus between the freedom of speech and assembly. The flip side of being allowed to associate with people that you agree with, though, is that you are also allowed to not associate with people you don't agree with. The Supreme Court most recently upheld this idea in 2023 in a case called 303 Creative via Linus. In that case, the court held that a web designer that specialized in wedding websites could not be compelled to create a website for a gay couple. You should of course be aware that there are laws that prevent refusal of service on the grounds of discrimination. Most notably, the Civil Rights Act of 1964 makes it illegal to refuse service to anyone on the basis of race, color, religion, or national origin. But not only are these the only federally protected groups, this is not a constitutional right, but is instead a right granted through statute by Congress. Congress granted the right, and Congress can take it away. This one's for all of you who've actually read the Constitution at some point, which, if you haven't, I'd recommend that you do. The 14th Amendment of the Constitution states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. That kind of makes it seem like there are these unlisted privileges and immunities that come with your United States citizenship, right? But if you ask yourself, what are they exactly? And you answer yourself with, I'm not actually sure, then you're on the right track. Before we can fully understand what this means, we need to recognize that a citizen of the United States actually holds two citizenships: citizenship of the United States and citizenship of the state that they reside in. The 14th Amendment also states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The fact that the Constitution says citizens of the United States and of the state wherein they reside implies that there are two citizenships. If there are two distinct citizenships, each one must have different privileges associated with it. Otherwise, what would be the point of both existing? And then crucially, in the later parts of the 14th Amendment, it states that no state shall enforce any law which shall abridge the privileges or immunities of citizens of the United States. When discussing citizenship, the Constitution mentions that two distinct citizenships exist, but then only mentions one as being protected. This means that privileges and immunities that flow from the United States citizenship are the only ones that are protected by the Constitution. In 1872, in a case known as the Slaughterhouse Cases, the Supreme Court significantly narrowed the privileges and immunities that flow from United States citizenship. These privileges were limited to the right of habeas corpus, the right to peaceably assemble, the right to petition government, the right to use navigable waters, the right to travel between states, and a few others like this. Basically, all civil liberties instead come from state citizenship. The right to work, the right to create contracts, the right to pursue a specific trade or profession, and most of the other things we want to do day to day, they all fall under state citizenship and are not protected by this clause of the Constitution. And finally, Congress cannot just pass whatever law it wants. The Constitution severely limits what Congress is allowed to pass legislation on. Modern Americans think of Congress as this incredibly powerful body, but really the only things the Constitution allows it to do are raise taxes, borrow money, establish citizenship rules, coin money, write laws on bankruptcy, establish a post office and roads, regulate copyrights, set up a federal court system, punish crimes committed on the high seas, raise an army and navy, declare war, and regulate commerce among the several states. This might sound like a lot when listed out, but try to keep in mind all of the things that aren't included. The list doesn't include laws about education, property ownership, marriage, divorce, driver's licenses, gun ownership, the entirety of criminal law, contracts, employment and labor rights, public health, morality, trademarks, basically everything else you might think that government could or should regulate. The issue, though, the reason we think of Congress as this incredibly powerful body, is because of what is known as the Commerce Clause. Remember how I said that Congress was granted the power to regulate commerce among the several states? Well, over the past 200 years, Congress has gotten better and better at arguing that something is related to commerce between the states, to the point that the vast majority of federal laws are passed using this one power, even if it doesn't really seem like a statute is related to commerce. The Civil Rights Act of 1964, Well, discriminating in places of public accommodations makes it difficult for people of color to travel across the country, which affects commerce. The Clean Air Act? Well, air pollution travels across state borders, making it an interstate problem, and having a clean environment and a healthy population benefits commerce. No Child Left Behind? Having a sufficiently educated workforce is important for commerce. This is obviously a broad power that Congress is willing and able to stretch to its limit, but there is a limit. An example is the Affordable Care Act. The part requiring people to purchase health insurance was struck down as not sufficiently connected to commerce. So while the power is broad, it's not unlimited. As I said in the beginning, this is a much more complicated area that I can go into more detail on if there's interest. But even this short intro into the topic is important to have. As a voter, you need to keep in mind what the federal government can and cannot do. Candidates for office, especially presidential candidates, often promise to pass things that Congress can't actually pass. And that's 10. Thank you very much for watching. If you liked this video or you learned something, please consider subscribing, and I'll see you next week.